Hi, I'm Rodger Citron. I'm the academic dean at Touro Law Center, and I'm here as a mouthpiece. My colleague, Myra Berman, who is the associate dean for experiential learning, she put together this presentation, including the text that I'm going to read to you. Unfortunately, she could not make it to the conference, and so I'm here reading her words. And she's an outstanding experiential learning dean, and as you'll see, she has much to tell you. So let's start. About 2 years ago, Touro introduced the Portals to Practice, a strategic plan for innovative program development that includes pipeline programs with new and specialized offerings. This presentation today focuses on the creation and enhancement of a first-year program. Given Touro Law Center's mission, we tried to develop a program that would start on the first day of school, a program that would help create practice-ready professionals with a commitment to social justice who would help serve the needs of the underserved in our communities. And we began where most law schools were just a few years ago, not at the pre-McRate vision of legal education, with law firms doing skills development and training, but rather with McRate's continuum, where law schools provide opportunities for students to develop not only knowledge, but also lawyering skills and values. Our goal, reflected in the first-year pro bono program, is to approach the 3 Carnegie apprenticeships, the knowledge, skills, values triad, from a multidimensional perspective, where we begin with a central core and build those apprenticeships outwards towards greater competency levels. To do this, we needed to change our curriculum, but not that much. We made professional responsibility a required first-year course in the spring semester, and it is taken concurrently with our expanded collaborative courts program, which includes court observation and working with a practitioner partner to provide contact with unrepresented litigants. Broadly, the objectives of the 1L pro bono programs are to assist unrepresented litigants in resolving legal issues, to work collaboratively with the bench and the bar, and to provide our students with an integrative opportunity where knowledge, values, and skills will be developed in the real world and linked with classroom learning. Specifically, our volunteer practitioners and students provide unbundled legal assistance in uncontested divorces and landlord-tenant proceedings. Because all litigants must meet financial eligibility requirements, students learn that we are providing help to these persons that they otherwise would not be able to afford. And through this program, students to begin to form their professional identities in ways described in this slide. And I think I might be one behind, so I'm going to jump to that text. And some of the problems we had and questions: would there be too little practice experience, or would it be too much, given first-year students cannot work under a practice order? There were difficult issues with logistics, but the courts and the bar were supportive. So what we do to prepare students for the spring litigant contacts is there's a poverty simulation activity in the fall facilitated by our Office of Court Administration. And what happens is, for 3 hours, students, judge, and practitioners role play as clients. And in the spring, we turn to hands-on training, culminating in client contact, which is sitting together at a computer, drafting divorce papers, or sitting in the courthouse doing intake with an unrepresented client, and then observing landlord-tenant negotiations. And the students are able to connect this with what they learn in their first-year classes. We get referrals from courts and lawyers, so they learn about collaboration between courts and legal services organizations. And in the landlord-tenant program, students actually observe judges appointing attorneys for limited engagement. In the initial telephone contacts, the first-year students, they're partnered with upper-level law students, and what they do is explain the Uncontested Divorce Project to litigants who call or who have been referred already. One of the most important documents discussed during this call and provided to us by the courts is the letter of limited engagement, which you see there. 3 essential phrases in the letter. There's an opening phrase: in conjunction with the New York State courts. This validates our program. And second, there's a clear statement of who we're assisting, the unrepresented litigant, and what task we're performing, which is preparing legal documents. Finally, we provide information about serving and filing the documents, that is explained to the clients. At the meeting itself, the student, the litigant, and the attorney sit together at the computer and put in data, and that generates the documents, which are then reviewed. The litigant is told about how to effectively serve the spouse and is then introduced to the project coordinator, who will provide future assistance as needed. The products. In the uncontested divorce and landlord-tenant projects, students interview litigants to gather information to help solve legal problems. In the landlord-tenant courthouse, the students learn about the need for attorney-litigant conferences and things like stipulations of settlement. And in the divorce project, they see court papers such as this, the summons with notice, which advises litigants of their rights, what they are, how and when they must be exercised. Students also see the affidavit of service and understand why it is important. This really helps bring to life the concept of due process, helping to integrate classroom learning with experiential education. Finally, students see that the complaint, it's generated not only by knowledge of the law in Rule 8, but also by applying that law to a client's particular situation. By the end of the first year, students have been provided not only with their 30 credits of doctrinal law, but have participated as fledgling members of the legal profession. Thank you.